Corte Suprema de Justicia, señor Juan Eduardo Fuentes Belmar. Presidenta del Tribunal Constitucional, señora Nancy Yáñez Fuensalida. Subsecretaria de Relaciones Exteriores, Ministerio de Relaciones Exteriores, señora Jimena Fuentes Torrijo. Señoras y señores expositores. Subdirectora de posgrado, Facultad de Arquitectura, Diseño y Estudios Urbanos de la Pontificia Universidad Católica de Chile, señora Caroline Stamm. Catedrático del Departamento de Sociología, Universidad Autónoma de Barcelona, señor Luis Lemkov. Director del Diplomado de Mediación y Resolución de Conflictos, Universidad Alberto Hurtado, señor Gonzalo Frey. Profesor titular y director del Instituto de Geografía, Pontificia Universidad Católica de Chile, señor Johannes Renner. Magistrada auxiliar Corte Constitucional de la República de Colombia, señora Carolina Restrepo. Investigador adscrito de Investigaciones Jurídicas, Centro de Investigación de Estudios Públicos, Universidad de Costa Rica, señor Mario Peña. Head of Department, Department of International Economic Law and Environmental Law, University of Göttingen, señor Peter Tobias Stoll. Profesor de Derecho Internacional Público y Derecho Constitucional, Departamento de Derecho Público, Pontificia Universidad Católica de Valparaíso, señor Manuel Núñez Poblete. Académico, director de posgrado de la Facultad de Derecho, Master on Environmental Law, Universidad del Desarrollo, señor Raúl Campuzano. Professor of the Public Understanding of Law Faculty of Laws University College London, señor Philip Sands. Jueza del Tribunal Internacional de Derecho del Mar, señora María Teresa Infante. Professor, Faculty of Law, Universidad de Ginebra, Suiza, Head of the Department of Public International Law International Organization, Logans Boisson de Jazourn. Jueza Ambiental de San Salvador, Corte Suprema de Justicia, República de El Salvador, señora Oneida Cáceres. Chairperson, National Green Tribunal, India, señor Adarsh Kumar Goel. Superior Tribunal de Justicia de Brasil y Presidente del Instituto Judicial Mundial del Ambiente, señor Antonio Herman Benjamin. Jueza Suprema Provisional de la Sala Penal Transitoria, Presidenta de la Comisión Nacional de Gestión Ambiental, Poder Judicial del Perú, señora Iris Pacheco Huancas. Directora interina, División de Gobernanza, Programa para el Medio Ambiente ONU, señora Andrea Brusco. Lecturer, Department of International Law, ELTE University, señora Kathleen Suljok. Ex jueza ambiental responsable de la Secretaría del Foro de Jueces por el Medio Ambiente, EUFJE, señora Farah Bukele. Juez delegado de EUFJE para Latinoamérica, señor Faustino Budín. Professor of Environmental Regulation, Co-Director, Law of the Sea Institute, UC Berkeley School of Law, señora Holly Daremos. Académico e investigador del Departamento de Ciencias Ecológicas de la Facultad de Ciencias de la Universidad de Chile, señor Rodrigo Medel Contreras, presidenta de la Comisión de Climatología de la OMM, profesora, Universidad Rovira y Virgili, España, señora Manola Brunet. Profesor Departamento de Recursos Hídricos, Facultad de Ingeniería Agrícola, Universidad de Concepción, señor José Luis Arumi. Juez de la Corte Suprema de Justicia de la Nación Argentina, doctor Ricardo Luis Lorenzetti. Presidente de la Sala Tercera del Tribunal Supremo de España, señor César Tolosa. Ministro Presidente del Segundo Tribunal Ambiental de Santiago, señor Cristian del Piano. Ministro Presidente del Tercer Tribunal Ambiental de Valdivia, señor Javier Millar. Ministra Presidenta del Primer Tribunal Ambiental de Antofagasta, señora Sandra Álvarez. Ministro Titular Abogado del Primer Tribunal Ambiental de Antofagasta, señor Mauricio Oviedo. Ministra suplente abogada del Segundo Tribunal Ambiental de Santiago, señora Daniela Sfer. Ministro suplente en Ciencias del Segundo Tribunal Ambiental de Santiago, señor Cristian López. Policía de Investigaciones de Chile, Unidad de Salud Pública, Medio Ambiente y Patrimonio Cultural, prefecto señor Luis Mardones Olivares, subprefecto señor Fabián Contreras, los comisarios señores Héctor Chaura y Marco Orellana. Representante de la Embajada de Brasil en Santiago, señor Leandro Rocha de Araujo. Seremi del Medio Ambiente, Región del Maule, señora Daniela de la Jara. Señoras y señores, nuevamente tengan todos ustedes muy buenos días y bienvenidos al quinto Foro Internacional de Justicia Ambiental organizado por el Segundo Tribunal Ambiental. Les recordamos que pueden seguir el desarrollo.
You can follow the event over the website and also the social media. And now I invite you to stand for our national anthem.
Por favor, pueden tomar asiento.
Please be seated.
El Foro Internacional de Justicia
The International Forum of Judges for the Environment began to address the need to have a regular opportunity to exchange experiences in various matters related to environmental justice. And so this has nationally and internationally materialized as the best event of its type in Chile and one of the main ones in the region. In its three versions, has brought together magistrates from higher courts, constitutionalists and environmentalists, academics and specialists in matters related to environmental justice, and the various expressions of environmental law at national as well as international level. And now we invite the Minister President, Chief Justice, Second Environmental Court, Mr. Cristian del Piano, Lira. morning, everyone, and welcome to this fifth International Forum of Judges for the Environment. It is an honor on behalf of the second environmental course to welcome such a diverse array of attendants who have been so kind to accompany us either in person or online. This event, we are accompanied by professionals from international organizations, international and international, from 14 different countries. On this occasion, we have also wanted to resume the traditional way that prior versions of the Forum on Environmental Justice had been held prior to the COVID-19 pandemic. And the idea is to bring the forum to an each time wider audience. And so we've implemented a hybrid system that is available in all our platforms. And also I would like to take the opportunity to welcome those who are following us online. And lastly, I cannot but thank each and every one member of this environmental court and who have contributed to the success of this forum. To name each one would be unfair, since there's always the risk of leaving involuntarily, leaving someone out. But my thanks for all, each and every officer. Since the fourth forum in January 2021, we have seen various instances in the country as well as in the court that we share. First milestone that I would like to relay, and is one of the main pillars of the forum, is given by the social environmental conflict. And in recent times, the Second Environmental Court worked intensely to identify mechanisms for understanding among communities, enterprises, and the state, and the demand for the historical contamination, which is the biggest cause that today affects the legal environmental system. In 2017, the process of reconciliation began, and as of now, 2019, the Second Environmental Court took up the leadership of the process and sought to propose grounds acceptable to all parties and that may be executable and enduring over time. And this was materialized in a process that involved a very intense work by the court and implied the definition of a methodology in order to carry out the process. More than 45 meetings, bilateral and with all parties and with other relevant actors. Field visits, requests for background information, and so on. And in this transit, we as a court aim to go beyond our legal mandate to resolve the environmental disputes, as indicated by Article 1 of the law, and our goal was to try and resolve the underlying dispute, or at least lay the grounds for its solution. Unfortunately, the reconciliation was frustrated due to a series of reasons that I will not mention here. However, we do understand that we must learn from the entire process, identify possible space for improvement so that in the future, hopefully not too distant, through mechanisms, alternative mechanisms, we may, as a court, be able to support a solution of environmental disputes and not only limit ourselves to resolving a conflict. Another relevant milestone has been the proposal of a new constitution, and that was rejected, as you already know, by citizens through a referendum in September this year. The text, with its lights and shadows, contained several proposals that meant that it was called an ecological constitution. Despite the rejection, we understand that the constitutional process continues, and in this context, the spirit of these words is to propose elements to bear in mind in a future constitutional discussion. This spirit of proposals implies the need to recognize that there are contributions that may be made from environmental institutionality in general. as the discussions are heard and integrated. And so, this can be seen as an authorized voice when it comes to contributing ideas that we would like to include in an environmental constitution. In fact, the work of the Ministry of the Environment in drafting environmental laws and policies, and same as their active participation in various laws, the framework law on climate change. And the same can be said of the Environmental Assessment Service. According to statistics in 2011 through 2022, almost 11,500 have been submitted for approval. And some of these projects were approved and others not, but the figures account for experience in this regard. In the same sense, the service may contribute to a practical approach to citizen participation, relations between economic activity and the environment. The superintendents of the environment, and also as part of the environmental institutionality, have almost 2,000 procedures that have been carried out.
It has received 20,000 complaints, and they are mostly 60% related to disturbing noise. And also compliance programs have been presented, and this is a practical implementation, enforcement, authorizing the regulator of the environment in terms of compliance of environmental standards. And there is no doubt with the environmental courts as part of the institutionality that materializes access to environmental justice in the work of interpretation has become a progress like active legitimacy, complainable acts, the environmental sentences, the use of alternative mechanisms of dispute settlement. These are some issues where case law in environment has addressed, and there are more than 250 sentences and other alternative mechanisms of dispute settlement. The debate of a new constitution cannot do without the contribution that environmental institutions can provide, because we've been able to know the reality of social disputes. The numbers reflect, and institutions know the strength of the present system and opportunities for improvement. These landmarks configure a part of our thematic survey that we will present. The first panel will refer to alternative resolution of environmental conflicts and within the context of complaints for environmental damage. The second panel will be about constitution and environmental disputes. And therefore, in this, comparative and international views will be addressed. The third panel is about arbitration and international courts and their role in environmental disputes. We have outstanding academics and persons linked to the judicial legal world. The fourth panel develops the subject of scientific basis of judgments, to have a broad view of how other jurisdictions have faced this. The fifth panel is precisely about this. Article 45 of 3600 law, created by environmental courts, forces to express technical grounds in the allegation. And this panel wants to underscore the importance of scientific investigation for an optimal discussion. The sixth panel will be importance of science in the resolution of environmental conflicts. The invitation is to have a participatory forum, not only guests to present your experiences, but each one of the attendants as the audience can contribute with questions and comments enriching the present subjects. It's our purpose as Second Environmental Court that this fifth International Forum of Judges for the Environment can be a true contribution and a learning of experiences and concepts that we will receive from speakers and panel members. I conclude these words inaugurating this fifth International Forum of Judges for the Environment. Thank you very much. We thank the words of Minister Judge Del Piano. The International Forum of Judges for the Environment has convened experts from different countries, bringing together a public of 200 people, professionals from different disciplines linked to the development of this subject in the country. The fourth forum, that was totally remote, was no exception in spite of all difficulties generated by COVID-19 pandemic, and thus we had two very successful learning sessions. The fifth International Forum of Judges for the Environment has brought together 30 speakers, judges, academics, experts from different areas, and will be with us on a face-to-face as well as remote version. This fifth International Forum of Judges for the Environment is divided into 6 thematic panels and master lectures that will refer to subjects like alternative resolution of environmental conflicts, constitution and socio-environmental conflicts, arbitration and international courts. To call to order this forum, we invite the Chief Justice of the Supreme Court, Mr. Juan Eduardo Fuentes del Mar.
Buenos días a todas y a todos.
Good morning, everyone. I will not repeat all the persons addressed by the chairperson. It's an honor to be part of this fifth International Forum of Judges for the Environment. And considering the situation of the environmental and economic situation that we face as a humanity, activities like this one seeking to enrich the debate in matters of environmental justice from different standpoints. This is a fundamental exercise into the future for our lives and for future generations. A future that is being jeopardized both by the global climate crisis as well as social unrest and crisis, health crisis, economic crisis of recent years. The list of challenges that bring a shadow into the future has grown to such an extent that a listing of those factors is inexhaustible. However, it's worth the while to go over some of them, at least. The threat of a nuclear war, the crisis of the largest economy of the world, the dangers of global warming and drought, the dangers of starvation and the migration movements in terms of vulnerability, marginality, and the need to accelerate our transition processes to cleaner energies. These are only a few of the problems that we need to address. We and future generations as well. Now, considering this landscape, and without the idea of evaluating the whole matter, it's necessary to ask a question. What is our present situation, and what are our hopes? What are we doing right? What are we doing wrong? And what is the path towards the future? Where have we made progress, and what is it that we need to cover and do? The answer to this question evidently is less simple. In connection with the future, at least if one is guided by authorized views on this matter, the situation is alarming. Perhaps there will be even more complex moments than the present one. The economic crisis could deepen, as well as the environmental and migration crisis. The problems are so many, so complex, that the challenge is very, very difficult. Therefore, it is of great significance that we focus on the other questions that I raised, those that are related to our own area of work before the crisis. What are we doing right? What is it that we still need to do? One of the things we've done right as a country is emphasize the role of environmental justice in our lives. Notwithstanding the debate existing on this, we've witnessed an institutional revolution on this matter, and we've transited from an area of scattered fragmental laws to an environmental institutionality with precise, accurate laws and regulations and covered by administrative and jurisdictional specialized agencies. It's not a matter of not listening to critics or criticism. We have all been able to see that and that with weaknesses, and that because of the interest that many situations have raised before the specialized community and the public in general. However, if we look backwards, with approximately 10 years of implementation, I think that the balance is positive, evidently. Of course, we still need a lot to do and to change, but it is evident that in our country, the environmental situation enjoys a much greater relevance than the one of a decade ago. And that regardless of what some think could have been ideal, we can consider our evolution as an important change towards a goal of achieving a more sustainable and fair world. Highlighting the importance of this instance for self-examination of our possibilities, today I would like to take the last minutes assigned to me to think and reflect about some specific matters. One that I deem Chile still is lagging behind with important debts. And I'm referring to the problem of access to justice on environment. According to the doctrine, access to justice in environmental issues can be defined as, quote, the possibility of obtaining a complete and fast resolution by judicial authorities of the legal dispute of an environmental nature, and that assumes that all persons are on equal terms in order to access justice and obtain fair, individual, or socially just results. This, of course, all these matters need to be deepened and expanded in reference to the Escazú agreement that has been recently ratified. This instrument has in its article number 8 that each party will guarantee the right to access justice in environmental matters in accordance with the guarantees of due trial. And this involves the duty to refuse and resort against and appeal against judicial decisions, the duty of having competent agencies with sufficient powers, and the duty of each state to establish positive measures that will enable citizens and relevant communities to start and to the institutional apparatus of environmental justice. All these measures are very relevant to understand the path to be treaded by the country. And therefore, I think it is important to measure in this point some of them. Should we adopt measures enabling the population to reduce or eliminate barriers of the access right to justice that could be affecting them? Do we need to create measures that will ensure the publication of the movements of access to justice? Do we need to have a systematization and dissemination of administrative and judicial rules? Do we need to interpret the mechanisms and translate them to different official languages when accessing this right? Should we make compatible the implementation of all these facts, considering the specific needs of persons and beneficiary communities, and especially those that are in a especially vulnerable situation? As you can see, after Chile ratifying this instrument, the requirements imposed by the demand of access to justice in environmental matters has evolved in a way that is radical and leaves us in a situation of debt. It's not enough to have instances or transparent tribunals or transparent institutions that we already have. Today, we need to start investing time and resources that will allow us to bring environmental justice to the population in a concrete and specific manner. The time is now of positive actions. The time is here that, as Escazú says, when circumstances specified in the last part of the Article 8 that states should guarantee and ensure the availability of resources, guaranteeing possible beneficiaries technical free assistance depending on the need. Now, once we reach this point, I think that the call we should place is across the board to all involved institutions, courts, governments, parliaments, administration, in order to conduct internal examination that will allow us to identify what type of progress can be achieved by each one of us in accordance with the margins of our institutional order and different competencies that make up the model of Chilean environmental justice. We need all the possible participation for this endeavor. Only in this way can we improve collectively the experience of the justice service that we are called to provide timely by the constitutional mandate. I honestly believe and hope that forums like this will contribute to that, and thanks to this, we may progress towards fairer, juster environmental justice and an ever more inclusive, egalitarian, and sustainable world. Our future depends on that. Thank you very much for your attention.